The other judgment also on criminal law is the Constitution Bench judgment in Sushila Aggarwal, which relates to anticipatory bail. Now here in Sushila Aggarwal, there were two streams of judgments which actually came up for consideration. There was one set of judgments like Salahuddin Sheikh, etc., which said that while granting anticipatory bail, there could be restrictive conditions, and they could be the bail could be limited in time. There was another set of judgments in Siddharam Mhatre versus State of Maharashtra that no conditions can be imposed while granting anticipatory bail. The court has considered all this trend of judgments and has unanimously resolved, although Justice Shah writes a concurring opinion, have resolved that for one, the principles of the earlier Constitution Bench in Gurbakh Singh CBA are reiterated, and the factors that will weigh with the court while granting anticipatory bail will be as enunciated in CBA, namely the nature and gravity of the offence, the role of the accused, the peculiar facts of the case, etc. The court has also clarified that while granting anticipatory bail, it is always open to the court to impose certain conditions as it may feel in the facts of that case, and that is the discretion of the court. The court has also clarified that an order of anticipatory bail need not be limited in time. In fact, the court has said that an order granting anticipatory bail can even continue to the conclusion of trial, and it is not necessary that in every case that the accused has to surrender at the stage when he is summoned by the court. Of course, there is a power to the police in case a situation arises under Section 439 subclause 2 of the code, that in case the police feels that there is occasion to seek the convict's arrest, that can be availed of by making a necessary application under 439(2), and in that case, the police could ask for the custody of the accused. But the important facts or the important decision, part of the decision in this case are twofold. One is that the judgment in Salahuddin Sheikh and those following Salahuddin Sheikh stands overruled, which said that you cannot have any restrictive conditions or limit the time, and regarding restrictive conditions and limiting the time, and also the judgments and following those in Siddharam Mhatre that no conditions can be imposed while granting bail. That has also been held to be incorrect and was overruled. The additional point in the case is that when an order of bail anticipatory bail is passed, that can also be questioned. And questioning an order of grant of anticipatory bail is very different from an order seeking cancellation on the ground of violation. Because an order that is granted, an order granting anticipatory bail could very well be questioned on the ground that it suffers from non-application of mind, relevant factors have not been considered, the nature of the offense has not been considered, etc. That is very different from saying that a person who has violated the condition of bail invites cancellation of the bail. So to that extent, the court has now exhaustively clarified the scope of grant of anticipatory bail, reiterated the principles earlier in Gurbakh Singh CBA, and of course laid down these additional clarifications regarding conditions that can be imposed, regarding the time factor, that it need not be limited by time, and of course also clarified that merely because an order of anticipatory bail is granted, it does not restrict the rights of the police to continue to investigate the matter. So it should not be construed that as if a grant of anticipatory bail is some absolution for the accused and he is free to do whatever he feels like. These are the two judgments that I thought I would cover as far as on some aspects of criminal law. The other judgment which also I believe Mr. Ramchandran briefly touched upon, but he thought I should perhaps discuss in greater detail. Sriharan,